We also acknowledge the presence of, from Nellore, we have the past chairman of Nellore branch of Southern India Regional Council of ICI, VME Subbarao. Can just, we'll acknowledge your presence, sir. We also have amongst us Chartered Accountant K. Sridhar from Sridhar Krishnamurthy and Associates. Thank you very much. And we have a journalist, CA turned journalist, CAD Murali also on the first row. And we have a very special person amongst us. He is a senior audit officer and he has served his service with the Airport Authority of India close to 3 decades. And during the last few years in his service, he was with the Regional Training Institute of Indian Audit and Accounts Department. We'll feel privileged to have the presence of Shri N. Vijayaraghavan, our chief guest, Honorable Justice Dr. Anita Sumanth. She is a BA in English Literature from Women's Christian College, Chennai, and a BL from Government Law College, Chennai. ML in Constitutional and Public International Law, University of Madras, and doctorate awarded by the National Law School of India, Bangalore, on the subject International Taxation, E-Commerce. Very, very special and niche area. Madam, we are very fortunate to have you among us. She joined the chambers of senior advocate Sri V. Ramachandran upon enrollment, practiced extensively before the Supreme Court, High Courts, tribunals, and other appellate fora, as well as the Authority for Advanced Ruling, specializing in direct and indirect taxes and corporate laws. She has held the position of Special Government Pleader Taxes, Madras High Court since June 2014, and appointed as the permanent judge of Madras High Court from October 2016 onwards. Friends, please join your hands welcoming Honorable Justice Dr. Anita Sumanth. Madam, the podium is yours.
Distinguished guests of honor, dignitaries of the days, ladies and gentlemen, I am indeed very happy to be participating in this function today with all of you. I had a deja vu moment about 3 weeks ago when Mr. Dhanapal walked into my chambers in the High Court. Almost a little over a year ago, Mr. Dhanapal had called on me to invite me to participate in the launch of the first edition of this book. Unfortunately, I was not in a position to participate then because I had a prior commitment. But why I am mentioning that now is because just over a year after the launch of the first edition of this commentary on the Insolvency and Bankruptcy Code, here comes the second edition. To my mind, this illustrates two positions. The first, of course, is the rapid development in the statute itself, or the march of the law, as we call it, the various developments that have taken place over the period of time between May 2017 and August 2018. And second, and equally important, is the very sincere and committed effort of the learned author to have monitored the changes that have taken place, codified it all, and brought out this extremely comprehensive and easy to read commentary on the IB code. So at the outset, my congratulations to the author, my best wishes. I have no doubt that the book is going to be a resounding success. I have had the privilege of going through the pre-launch version. The learned author was good enough to circulate a thick tome of a spirally bound version of this book. And let me tell you, it gave me sleepless nights. And I found it extremely easy to read. As almost every speaker prior to me has mentioned, the tabulations, the flow charts, the lucid flow of material made it a very, very comprehensive and a wonderful book indeed. The stakeholders in this area of practice, both the professionals who are practicing before the National Company Law Tribunal and the courts, the companies themselves and the general public, including the student community, will no doubt find it a very, very valuable addition to their libraries. Now, coming to the code itself, I must confess that I'm not an expert when it comes to the nitty-gritties of the code, seeing as it was introduced in 2016 May. The ordinance itself was promulgated in December 2015, and the act was passed in May 2016, came into effect from December 2016, and that was about the time when I was elevated. So I did not have occasion to practice in this area before either the NCLT or the code or the courts. And upon elevation, the company courts, I should say, lost a fair amount of their luster because almost all matters, company court matters, got transferred to the NCLT. So even portfolio judges who were given the portfolio of company jurisdiction found that the portfolio was extremely limited post 2016 May. But having said that, there are some general observations and general based on what we see in the press and in the reports today. I just wanted to share one or two observations with you. As you're all aware, I'm bringing coal to Newcastle. The audience here is a very, very erudite audience comprising professionals and people in companies itself. The code was brought in with the intention to make India a more responsible country in terms of managing the debt. Of course, I wanted to just quote that the objects and reasons says the new rules will, quote unquote, improve credit culture, reduce debt default, make banks more proactive in dealing with NPAs, and reduce bad loan accumulation in future. To this end, we have found over the 2 years that the code has been in existence, particularly from the last 1 year, there have been very, very significant amendments that are covered in the course of this book itself. When Mr. Dhanapal met me, I was surprised when he said that the new edition of the book is almost entirely a new book because almost 60% of the first book stands effaced by virtue of the amendments that have come in. As you're all aware, these amendments are extremely significant. One is, of course, the extension of the book to cover guarantors, personal guarantors as well. Second is where sole proprietorships have also brought in within the ambit of this code. And my favorite amendment, if you ask me, is that homeowners or prospective homeowners have some light at the end of the tunnel. I was sitting in Section 9 applications under Section 9 of the Arbitration and Conciliation Act. And you will not believe the number of applications that we had filed by, I would not use the word disgruntled, by pathetic owners, prospective owners who had invested life savings in real estate projects and were just waiting for the projects to take off and to be completed. To that end, the amendment that has come up now to say that homeowners are going to form part of the committee of creditors and will have a say in the restructuring, etc., of the company is indeed a laudable amendment and one that I think will give solace to a great number of people in the country. There are also a lot of amendments that have come in with regard to the MSME sector, and I'm not going to go into the details of that. I will leave that to you when you peruse this publication. But the rules for the corporate insolvency resolution process itself have been streamlined greatly and made more effective. 2016 was indeed a big year for India. We had the rolling out of the Goods and Service Tax Act. We had demonetization, and in addition, we had the Insolvency and Bankruptcy Code as well. And when compared to the former two, I think the code did not really catch the attention of the general public because it was the former two that overshadowed the code. Now we are in 2018, and much water has flown under the bridge as far as GST is concerned. Things are moving along in their own sweet way. As far as demonetization is concerned, I think people have reconciled, whatever it may be, that's the end of that chapter. So it is now time for, I think, the IB code to really be effectively implemented. For any code or statute or any enactment to be effectively implemented, we will need the involvement, the participation of all the entities, collateral entities, entities that can support it. We have the Reserve Bank of India that has issued the famous February 2018 circular. And that circular, the two major provisions being that even 1 day of default would mean that the institution is a defaulter, and you are given only 180 days within which you are to resolve the discrepancy or the default. A challenge to that was in fact turned down by the Allahabad High Court. The stressed power companies had approached the Allahabad High Court saying, look, we cannot do this. 1 day default is par for the course as far as the power companies are concerned. Please give us some relief. We cannot resolve everything in 180 days. The High Court said no. In spirit, I believe, implementing the provisions of the code. And the Supreme Court confirmed the order of the Allahabad High Court declining to interfere in their order. Therefore, I think the High Courts are also doing their bit to ensure that the code is preserved and implemented in letter and in spirit. As far as the Section 17 moratorium is concerned, courts have also been taking the view that the moratorium is to be very, very strictly enforced. In fact, sitting in Section 9, I had occasion to decide which would take priority, whether it would be other enactments or the moratorium under Section 17, though, of course, different courts had taken different views at that point in time. I noticed that the Supreme Court has, on the 10th of August 2018, delivered a judgment in the case of Principal Commissioner of Income Tax versus Monet. Let me give you the citation. Monet Ispat and Energy Limited, to the effect that, thank you for that, whoever told me the name, to the effect that the provisions of the Income Tax Act would not override, and it is the Section 17 moratorium under the code that would override all other enactments, including the Income Tax Act. Therefore, we are at a time now when the code is all set to take off, to be implemented. It has been given teeth now by virtue of the 2018 amendments. And this publication is no doubt going to go a long way in clarifying the issues that have been thrown up. I wish the publication and the author all success. Thank you.